Hi folks, welcome to SQE1 window, and chapter 2 talks about police investigation and evidence, and we will look at from interview to charge process, charging the accused. So this is a core of police investigation. That's what we will try to discuss today. So this is the stage where evidence is actively created, tested, and sometimes compromised. Everything from this point onward determines whether a suspect will be charged, cautioned, or released. For the SQE1, it is vital that you first identify which stage of the investigation is being tested. Interview rules, identification procedures, forensic powers, and charging decisions each sit under different legal framework. So if you misidentify the stage, you will almost certainly apply the wrong rules. So always pause and locate the procedural moment, where it is, the timeline of procedure. To start with, what counts as a police interview? A police interview is not limited to a formal room with recording equipment as we see at videos. Legally, it is any questioning that relates to a person's suspected involvement in an offense. It must normally be conducted under caution and usually at a police station. The police cannot bypass Code C by labeling questioning as an informal chat. If the questioning is designed to elicit admissions, Code C applies. For the exam, always ask whether the suspect was effectively being questioned about an offense, regardless of how the police described the interaction at that point. So it is formal, it is under caution most of the time, so that's what we need to keep in mind, and normally it is held at police station. So fitness for interview is a continuing obligation. Initially, the custody officer assesses fitness, often with input from officer in charge or healthcare professional. However, fitness can change during detention. That's why obligation continues, the fitness obligation. If a suspect becomes distressed, tired, intoxicated, or unwell, the interview must be paused or stopped. Vulnerable suspects require extra care. So in SQE1 scenarios, this issue often appears. So look for signs of exhaustion, mental health, concerns or distress, and consider whether continuing the interview was lawful or not. That's what is the question you should keep in mind. So the next thing is, before the interview even begins, effective defense work takes place. A police station solicitor must first explain their independent role and confirm that advice is free. Next, they take a full account from the client, assessing comprehensions, welfare, and capacity. Only then do they consider disclosure and strategy. In the exam, candidates often jump straight to silence or prepared statements. Not at all. It does not work like this. Remember, proper advice can only follow proper understanding of the case and the client at that point. So the next thing is interview options that can the client do at that point. So a suspect has several lawful choices in interview. They may answer all questions, remain silent, answer selectively, or give a prepared statement followed by no comment. None of these options is automatically correct. Each carries legal consequences. The SQE tests whether you can weigh these options in light of disclosure and evidence strength. So the correct approach is always contextual. Ask how strong is the prosecution case and how complete is the disclosure at that point. So there is no one right option at that point. No comment and adverse inferences. Very, very important for your SQE. Silence can now carry consequences. Under Section 34, if a suspect later relies on facts not mentioned in interview, the court may draw adverse inferences. This risks, and the risk increases when disclosure is good and the evidence is strong at that point. A prepared statement can sometimes reduce the risk by setting out the defense position early. So in exam question, always link silence to disclosure quality. So silence is most dangerous when the suspect has been given a fair opportunity to explain. So the caution is not just a formality. The standard caution warns of adverse inferences and is used when legal advice has been offered or taken. The alternative caution is used where advice has been delayed and omits the inference warning. If the wrong caution is given, fairness may be compromised. The SQE question often tests this indirectly, so check carefully whether legal advice was available at the time of caution or not. So this is how you can decide between cautions. So the next thing is recording the interview and why it matters. Audio recording protects both the suspect and the police. For indictable and either way offenses, recording is mandatory. So the defense receives a written summary, but if that summary is inaccurate, the recording prevails. Where there is a dispute, a full transcript can be produced. So in SQE1 answers, recognize that recording are central to later challenges about what was said, how it was said, and whether pressure was applied on the accused or suspect at that point. So fairness, it's a big thing. Of course, like accused is the favorite child of law. Police questioning must never be oppressive. Threats, inducement, bullying, or any pressure is prohibited. If a confession is obtained through oppression or unreliability, it may be excluded under Section 76. Even if Section 76 does not apply, unfairness can still justify exclusion under Section 78. For SQE purpose, oppression relates to how evidence was obtained, while Section 78 focuses on overall fairness of proceeding. So the next is interview room. Practical fairness signal. Fairness extends beyond words. Interview room must be adequately heated, lit, and ventilated. Too many officers present may feel intimidating. Officers must identify themselves, and everyone present must be recorded. Environmental pressure can undermine reliability. So in exam scenarios, these facts are rarely included by accident. Always ask whether the environment contributed to unfairness or unreliability if it is part of your exam. So solicitor during interview. A solicitor must actively safeguard fairness during interview. They should intervene if questions are misleading, repetitive, or oppressive. They may request breaks to advise privately and challenge incorrect assumptions put to the suspect. They also ensure the accuracy of record. For SQE questions, intervention is justified whenever it is fair. So you cannot stop interview, you cannot intervene, but at that point when it impacts fairness as a solicitor, of course you can intervene. So ending the interview. The interview should include once all relevant questions. So the police must properly test any innocent explanation rather than ignoring it. Often the police must decide whether to charge, release, or bail, or continue detention at that point. Defense solicitor can make representations at this stage. So in questions, they often ask what happens immediately after interview. So remember this decision-making phase after once interview is concluded. eyewitness identification is inherently risky. Even honest witness can be mistaken. The first description given in the benchmark against which later identification is judged. So for that, Code D governs all formal identification procedures. The court they should apply Turnbull warning at trial. So breaches of Code D may justify exclusion under Section 78. In SQE answers, always identify the safeguards that should have been followed in case of eyewitness identification. So known versus unknown suspect, whether a suspect is known or unknown, fundamentally alters what identification methods are permitted. If a suspect is known and available, photo identification is usually appropriate. Photos showing are mainly for known suspects. All decision must be recorded in SQE question. Improper photo identification is a frequent trap. So formal ID procedure. So there are 4 formal identification procedure. Number 1 is video identification. Number 2 is identification parade, group identification, and confrontation. So video identification is now standard. Confrontation is used only as a last resort. So it's not always like, you bring witness and suspect in front of each other. The choice must comply with Code D rules. In the exam, you may be asked not just which procedure was used, but whether it was justified or not. So the next thing is forensic powers. So police forensic powers are extensive but regulated. Fingerprints and footwear impressions may be taken with consent. So at that point, but with consent or compulsorily as well. Non-intimate samples can be taken without consent. Intimate samples requires both consent and a healthcare professional advice at that point. Records must justify the use of force if any is used. So SQE question often test whether the correct classification of samples was applied or not. So if it is non-intimate, it can be taken without consent. So if it is intimate, it must be taken with consent. That's what you should keep in mind. So the next is charging. Charging authority depends on seriousness. Police may charge straightforward cases, but most serious or complex matters go to CPS. So charging decisions are governed by the full code test. First, is there a realistic prospect of conviction? That's what police or CPS questions or asks. Second, is prosecution in the public interest? So SQE questions frequently ask you to apply these 2 stages like systematically at that point, whether you understand it or not. So 2 stages, once again, is there a realistic prospect of conviction? Second, is prosecution in the public interest? Should we invest time, energy, and money on it or not? So threshold test, like the threshold test applies when evidence is incomplete but further evidence is anticipated. The case must be serious and requires immediate charge, and there must be substantial grounds to refuse bail. So pre-charge bail is time limited. So but it can be extended. So candidates often confuse this with the full code test, so keep the distinction clear. So out of court disposals, you have heard it on media, like someone was given caution before. So caution provides alternatives to prosecution. A simple caution requires sufficient evidence and admission and public interest justification. So conditional caution add enforceable conditions. So the suspect must understand the consequences of acceptance. Not all offences are eligible. So in SQE question, eligibility and procedural correctness are central, and for that you should just look at our notes. So the last thing is SQE1 tips and pitfall. So you need to separate Code C interview from Code D ID identification. So always separate interview issues under Code C from identification issues under Code D. Both of them, they are different. So identify silence and adverse inferences risk early. Remember, operation leads to Section 76, but general unfairness to Section 78 exclusion. So known suspect plus photo identification is a major error. So intimate samples always require consent and a healthcare professional. Finally, never confuse the full code test with the threshold test. And I wish you all the best. And if you like this video, subscribe and share it with your friends. I wish you all the best. Ta-ra.